Donald Trump submits his brief to the United States Supreme Court declaring his J6 case should be dismissed because he has presidential immunity. We've been following this from Judge Chutkan's courtroom all the way up, and we are waiting for oral arguments on this case, but both sides have to brief this matter, and Trump submitted his. It's a 67-pager. We're going to hit the highlights of it after we lay some foundation, because there are two main questions that we're going to have to be grappling with as we go throughout this brief, and some other useful words and phrases that I think it'll be appropriate to understand before we dig in. But the big question, of course, is does the president have criminal immunity? We've already talked about civil immunity, and that's been settled in Nixon, and we'll talk about that when we go through the brief, but it's criminal immunity against prosecutions like Jack Smith on the classified documents case, or in this case in particular, the January 6th case. And if so, if the president does have some sort of criminal immunity, what kind of immunity? Is it absolute immunity or extend? So for example, does a president only have immunity when he's in office? Or maybe he loses it when he's out of office? Or do you have immunity both in office and both out of office? Or do you retain immunity once you're out of office for any of the conduct while you were in office? What are the rules? What are the elements? What are the tests? Are you immune from state prosecutions? Are you immune against state criminal charges or only against federal criminal charges? And when we ask ourselves, if you are immune, is it only for official acts or is it for everything? Because it should be only for official acts. And if it is only for official acts, well, how do you measure what those official acts are? What is the test to determine what is inside the perimeter of the outer perimeter of the official acts? So those are the things we're asking ourselves. And there's a lot of different ways this could go. Now, before we jump into the brief from Trump and co., we want to make sure we disambiguate between the different types of immunity. Starting at the bottom, obviously, pretty easy. No immunity. Okay, most of us don't have any immunity. We get charged with the crime. That's too bad we get charged. We can't declare some sort of privilege against the prosecution by saying that we are immune. That's most of us. Now, you're familiar with some of these other types of immunity. Of course, qualified immunity. We talk about this a lot with police officers. Police officers, if they're acting within the scope of their profession, essentially, if they're not grossly negligent, then they have qualified immunity doing their job. If they arrest somebody, you bump your head, oops, that's in something that is related to your arrest and it's incidental to what was happening. It's not the cop's fault, right? He's immune from that. He has qualified immunity. Then we actually have in the law something called absolute immunity. Now, I want to explain that this is for people like judges and people like Congress people if they are acting within the scope of their duties. So when a judge is acting as a judge or when a congressperson is acting as a congressperson. Now, the question for us is, does the president also have this type of absolute immunity? But many people hear the word absolute, and if you think about the word absolute in layman's terms, you think, well, that's like unequivocal, right? No one can challenge that. It is absolute. It is uncontestable, right? You have no one who can challenge you at all. So when you think of absolute immunity, you think some dictator from some country that throws their opponents in prison. Oh, that's America. Oh yeah, I forgot. But you know, in a Hollywood movie or something where these tyrants exist and they have total absolute control and they just say, oh, you're dead, right? And opposition party's all dead. There's nothing anybody can do about it. That's not what we're talking about here. Now, that is the type of immunity that deranged people on MSNBC and elsewhere are saying, right? They will use the phrase absolute immunity to talk about a tyrant dictator who can do whatever they want, like executing SEAL Team 6. So that's not what we're talking about, right? There's an actual legal concept called absolute immunity. So when Trump references that in this filing, that's what he's talking about. He's not talking about deranged, executing SEAL Team 6 type of stuff. And if you want to just see how these things are disambiguated, let's go over to Wikipedia. They got here just a brief article on absolute immunity, okay? It is a type of immunity for government officials. It's not just for Trump. We're not making this up like this is going to be some new thing that we're just going to slap as a sticker on Trump's forehead, right? This is something that exists. It is creating immunity from criminal prosecution so long as officials are acting within the scope of their duties, okay? Executing using SEAL Team 6 to wipe out Congress is not within the scope of your official duties, unless arguably you made the case that it was. Maybe they were all, infiltrated by communists or something. Make your case. But the point is, it exists. Absolute immunity exists. It says the Supreme Court has consistently held that government officials deserve some type of immunity from lawsuits, and absolute immunity is different than qualified immunity, which sometimes implies to other officials. Now here, of course, absolute immunity. Now you're going to hear a lot of people on the left and all over MSNBC screaming about absolute immunity, and they're using the deranged definition in quotes that they take to mean that you can literally do whatever you want. It's like James Bond. You have a license to kill. Yeah, just go take out your opponents. Just go execute people, whatever. That's never been what Trump is arguing. You'll see the phrase phrase, absolute immunity, but it means something like this. Lawmakers engaged in legislative process. Okay, so Congress people doing congressional things. Guess what? They get absolute civil immunity. You've got judges acting in their judicial capacity, government prosecutors making charging decisions, executive officers while performing adjudicative functions, absolute immunity, and the president has it for civil cases. Now we're asking ourselves about criminal prosecutions. Even presidential aides may require absolute immunity. So this happens all the time, right? So every time that they say, he wants absolute immunity to murder people, relax, psychopaths. Do you know the difference between absolute and qualified immunity? Because absolute immunity is already a thing. Trump's not inventing this and pulling this out of somewhere and making it up. It's a real thing. And that's what he's arguing. And by the way, it's for his official acts, just like a judge in his judicial capacity or just like a congressperson in their legislative capacity. So it's within the confines of the law. But you'll hear a lot of people, I'm thinking in particular of people like Katie Fang, who every time she posts a story about this says absolute immunity. Trump's arguing for absolute immunity, so he can just, eliminate your whole family. Relax. That's not what he's saying. So that's a little bit of the background there on distinguishing between the different types. Now, other things that we're going to see is that the impeachment judgment clause, which is in the Constitution, that also gives them an ability to breach the immunity. Okay? So even if you have absolute immunity, our definition, the legal definition, not the psycho definition, absolute immunity can be breached by simply impeaching the president. So for example, if we want to go back to the SEAL Team 6 hypothetical, let's take it back. We call out Jack Bauer in 24 and we bring a whole situation where the country is about to be infiltrated by communists and Russians and Putin, and we're about to be seized and everything. And the president has to pick up the phone and say, Jack Bauer, do it, take him out. And then half Congress, goes away. You go, oh, wow, that's pretty serious business. But, hey, maybe that needed to happen in order to save the country or whatever. Well, if you want to go through that scenario, it should be very simple, right? You got to impeach the president and then convict him, provided that, half of Congress is not taken out for whatever reason. And again, I digress. If half Congress is blown to oblivion, this country is in a whole different game. We're talking about a total collapse of the government, right? If we go down that road. But you get the point. Very simple. If you can make the claim that it's within the official perimeter, the official acts, if you can make that argument, all you got to do is impeach them and convict them. And we know they can impeach people very quickly because Nancy Pelosi did it twice and failed both times to convict. So every time you hear absolute immunity, it's not, quote, absolute immunity, and the absolute immunity can be breached provided they impeach the person. And the person in this case is Trump, and he was impeached, but they failed to convict him. So they've already tried taking a bite at this apple and they lost. And so that is the background. We also have Marbury versus Madison. Of course, this case is a seminal case in American law and one on which the Trump defense is hanging a lot of their arguments. And so Marbury versus Madison says that a court, their argument will be, cannot sit in judgment over a president's official acts. Because if the court can sit in judgment over the president's official acts, the court is the president, which nobody wants. That's a separation of powers problem. So with all that being said, that's the background, that's the foundation on this filing. And it is, I think, going to be one of the most important cases when decided that we'll see in this country, perhaps in our lifetimes, as it relates to the structure of our federal government. So with that all said, let's get into the brief. Filed in the Supreme Court of these United States. This is the big one. The brief of petitioner Donald Trump on appeal from Judge Chutkan on the January 6th case, from her courtroom up through the U.S. Court of Appeals, up now into the United States Supreme Court. Donald Trump, Jack Smith is the respondent. Trump and his team asked the question to the Supreme Court. Question presented is whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office? Question. So does he have immunity? And if so, to what extent? Two questions we talked about. Trump's team writes, all right, Supreme Court, from 1789 to 2023, no former or current president faced criminal charges for his official acts, and for good reason. The president cannot function, and the presidency itself cannot retain its vital independence if the president faces criminal prosecutions for official acts once he leaves office. The president's personal vulnerability is something we talked about in a prior case. You remember the Supreme Court back in 1982? We were here in the case called Nixon versus Fitzgerald, and we decided that a prosecution would distort, quote, your words, not ours, the president's decision-making process with respects to official acts. Also citing here a 2020 case, Trump versus Vance. Now, a denial, Supreme Court, of criminal immunity would incapacitate every future president with a de facto blackmail and extortion while in office and can condemn him to years of post-office trauma at the hands of his political opponents. Sounds familiar. The threat of future prosecution and imprisonment would become a political cudgel to influence the most sensitive and controversial presidential decisions, taking away the strength, the authority, and the decisiveness of the presidency. The D.C. Circuit's ruling, if allowed, Supreme Court, to stand, would deeply wound the president by substantially reducing the president's ability to protect himself, saying, here's some background on where this immunity arises from, telling us that a president's criminal immunity arises directly from the Constitution, from the executive vesting clause, and from the separation of powers that exists in the structure of our governance. They take us back to this case, Marbury versus Madison. In that case, they said this court held, they wrote this back in 1803, at the very founding of this country. They said this court held that a president's official acts can never be examinable by the courts. That makes sense, right? Otherwise, the courts are the president. President does something, the court says, oh, wow, I'm not real sure about that. Okay, well, then maybe you should run for president. Judge, thanks for your opinion. But you're not. You're a separate branch of government, separate but equal. You don't get to tell us what to do. Thanks for playing. A doctrine that this court has reaffirmed over 2 centuries, time and again. Now, continuing Marbury's tradition, this court held in 1982 that the courts cannot hold a former president personally liable for acts within the outer perimeter of his official responsibility. That's the civil case from Nixon. And so they tell us that the court should restore the tradition that we've already had in place from Marbury to Fitzgerald, unbroken until last year, thanks Jack, and neutralize one of the greatest threats to the president's separate power, which is a bedrock of our republic in our nation's history. The court should uphold the president's immunity from criminal prosecution for official acts. Now, they give us a statement of the case. They tell us on August 1st, 2023, President Trump was indicted on 4 counts for alleged conduct during the presidency following the 2020 election. Now, the indictment from Jack Smith charges Trump with 5 types of conduct, all constituting official acts of the president. So how can he be charged with a crime? Now, even Jack Smith's indictment says in the original indictment, it admits that he used official power. That's the power of the presidency. Now, first, it alleges that President Trump, using official channels of communication, made a series of tweets and public statements on matters about the 2020 election. He said that the election was rigged, tainted by fraud, and it should be addressed by government officials. All something you'd expect the president to do. We don't want our president, that is the enforcer and the executor of the laws, to allow our elections to be rigged and stolen. Second, Jack Smith's indictment alleges that Trump communicated with the acting attorney generals and officials at the DOJ regarding investigating suspected election crimes and whether to appoint a new acting attorney general. Again, all those communications were his lawful rights within his powers. Third, the indictment alleges that Trump communicated with state election officials and urged them to exercise their responsibilities, saying, investigate your rigged elections. Fourth, the indictment says that Trump spoke with Mike Pence and encouraged him to follow his official duties, and Trump had voluminous information that was available to him that the election was tainted by extensive fraud and irregularities. And fifth, the indictment alleges that other individuals organized slates of alternate electors from 7 different states that would help ensure that Pence would be authorized to exercise his official duties if the election were reversed. According to the indictment, these alternate electors were designed to validate Pence's authority to conduct his official duties that Trump urged. Now, backing up, Trump, when we were in Judge Chutkan's courtroom, he moved to dismiss the indictment in front of Judge Chutkan. Now, Chutkan wrongfully held that a former president enjoys no immunity from criminal prosecution for his official acts. None. The D.C. Circuit affirmed. They incorrectly also held that a former president has no immunity from criminal prosecution for official acts. And this court granted cert. Now, I want to pause here for just a brief minute and show you a contrary argument on this. So there is this response that says, no, Rob, you're just a dum-dum. You're reading Marbury wrong. How could you read Marbury so wrong? We obviously can sit in judgment of a president's official acts, and Judge Chutkan was right. And so this person who has a terrible take on this, but is in alignment with Chutkan, is named Norm, and he posted this. He says, the D.C. Circuit points out that Trump people get Marbury backwards. That does not absolutely insulate presidents from judicial oversight. It empowers the courts to reject this lunacy like Trump. All right, so he's referencing this opinion from Chutkan, and this is what Chutkan wrote. So she said, no, sorry, President Trump misreads Marbury and its other progeny, its other cases. And just to be ultra clear on this, the Marbury case is seminal in American law. It establishes judicial review. It's like Neo in the Matrix. Like everything comes out of this, one case. It's really, really powerful. So Chutkan says, no. Sorry, Trump, you don't get to rely on Marbury. And we just said Marbury says that the courts can't sit in judgment over the president's official acts. Otherwise, the courts are basically the president. Chutkan says, no, you read it wrong. Marbury distinguished between two different kinds of official acts. She said discretionary and ministerial, right? So she says, okay, there were two types of acts. And watch what she does here. It's very sneaky and clever, but I think it's erroneous, which is why their arguments will fail. Says, as to the first category, Marshall said, yeah, the president is invested with certain important political powers in the exercise of which he can use his conscience, and he's only accountable in political character to his country. But she continues, when the president or his appointed officers, right? See how that we go from the president now, we're talking about the president, and now we're going to the officers. So watch how this little substitution happens from Chutkan, or his appointed officers, when the subjects are political and the decision of the executive is conclusive, and their discretionary acts from these people can never be examinable by the courts. But Chief Marshall continued, when the legislature, this is from the Marbury case, proceeds to impose on that officer other duties, so Congress now wants to act upon the president, for example, when he's directed to do certain things, when the rights of individuals are dependent on the performance of those things, then is amenable and cannot at his discretion sport away the vested rights of others. Now here he says, right, he is so far the officer of the law. See that word officer there? They say that she's trying to say that the president is an officer of the law, essentially, and that the president is subordinate to congressional legislation. Wrong, Judge Chutkan. If they want to impose upon his already constitutionally established powers, they have to amend the Constitution to encroach upon those powers. That's the hold from Marbury when they invalidated the Judiciary Act, saying that was unconstitutional. That's the whole point. So she misses it. Now, under these circumstances, right, she says, an executive officer, so she says Trump is an officer, which we have not seen that decided yet. So she's putting him subordinate, in that categorization, that they act as a ministerial officer, then he has to follow the law. And so she tries to get out of Marbury by saying he's an officer and that basically the officers are subordinate to congressional legislation. It is such a disgusting, perverted interpretation of the law. I can't even believe she wrote that, but all right. So here is what Trump says. Here's a summary of his argument. So I think Chutkan was absolutely wrong. I think Marbury is where they're going to hang their hat, and they should. So here's their argument. A former president enjoys absolute immunity from criminal prosecution for his official acts, saying criminal immunity arises from the executive vesting clause and separation of powers. And this court has routinely held that Article 3 courts cannot sit in judgment over the president's official acts, and courts cannot sit in criminal judgment either. Now, there is a limitation on this. There is an escape hatch. So for all of the MSNBCers who were petrified that Trump is going to, execute Congress or whatever, they've already tried to impeach him and they failed. Trump's team says the impeachment judgment clause reflects the founders and their understanding that only a president convicted by the Senate after impeachment could be criminally prosecuted. The Constitution authorizes the criminal prosecution of a former president, but it builds in a formidable structural check against politically motivated prosecutions. We have a safety guard. It requires a supermajority of the Senate to authorize that. You have to impeach the president and convict them by 2/3. Only then does that force field of immunity, shields are down, Captain, then you can bring in a charge. Now, the founders carefully balanced the public interest. They ensured accountability for the president and the moral danger to our system that could come by targeting the president. This is Trump writing to SCOTUS. The long history of not prosecuting presidents for official acts, despite ample opportunity and motive to do so over the years, demonstrates that this newly discovered alleged power to prosecute does not exist. This lack of historical precedent provides a telling indication of a severe constitutional problem with this asserted power. And further telling, Your Honors, is the fact that criminal immunity is more deeply rooted in common law, the president's civil immunity, and now you're going to hem and haw over criminal immunity? They say, let's talk about this. Functional considerations that are rooted in the separation of powers, which you emphasized in the Nixon case, compel a finding of criminal immunity. You can't find otherwise. You already ruled in Fitzgerald Nixon that it exists, so how can you change? The threat of future prosecution, you said, would distort bold and unhesitating action, requiring an independent executive who's charged with some of the most sensitive and far-reaching decisions entrusted to any official under our constitutional system. And as the recent history of impeachment demonstrates, once our nation crosses this Rubicon, Supreme Court, every future president will face de facto blackmail and extortion while in office. And and will be harassed by politically motivated prosecution after leaving office over his most sensitive and controversial decisions, or they just won't do anything, right? So the bureaucratic state constantly gobbles power, and they find different ways to do it. If it's not officially gobbled up via statute, we just have permission or implicit attacks. So now the presidency would be captured by the litigators, by the prosecutor's office, by the DOJ. Oh, you don't want to do that, do you? Otherwise, they're in charge. What happens if Trump says, I want that declassified? Someone says, sorry, Mr. President, you can't declassify that. He says, I don't give a crap what you say. I am the president. You are not. Sit down. And they say, oh, you violated the law, just like we have happening right now. That's a problem, right? We didn't elect that person, and that person is not the executive branch, and they are usurping the Constitution. So if we now say that every person who has even an inkling of prosecutorial power can take out the president, that's a big problem for the country. That bleak scenario would result in a weak and hollow president, and would thus be ruinous for the American political system. That vital consideration alone resolves the question and favors dismissing this case. Now, the next question of a former president's criminal immunity presents grave constitutional questions. In addition to the clear provision of presidential immunity from criminal prosecution based on the executive vesting clause, okay, the executive branch has the power, and the separation of powers, it dictates that generic criminal laws should not be construed to apply to the president or his official acts, because the president is the executor of the laws. Now, the court requires an express statement by Congress before assuming it intended the president's performance of his official duties to be subject to judicial review. In other words, Congress has not said that. This court means that Congress has to say this, and silence alone is not enough to subject the president to these provisions. Now, this court is loath, they're citing a bunch of case law here, loath to conclude that Congress intended to press ahead in this constitutional thicket, but none of the criminal statutes charged in Jack Smith's J6 indictment contains anything resembling a clear statement that it applies to the president or to his official acts. There is no indication that Congress intended to provoke the ultimate interbranch conflict by abrogating presidential immunity and authorizing the prosecution of the president through sweeping, vaguely phrased criminal laws. And so Franklin's clear statement rule resolves this case and mandates the indictment's dismissal again. So, Jack Smith is taking generally applicable laws and trying to apply them to the presidency in a way like, the president is the executor of the laws. So if you're charging the president with executing the laws, right, like literally, okay, it is the president's duty to make sure that we don't have rigged elections. Like literally, that's part of his job, right, as the executor of the country. Now, Trump's not going around checking ballot stubs, but through the FBI and the DOJ, through their investigatory arms, they are supposed to enforce the rules. So if you charge Trump with a crime for enforcing the rules, which is what he was doing, it's like dividing by zero. It doesn't work. That should dismiss the case. The court should also dismiss this indictment. Now, if it somehow does not, if it allows this charade to continue on, in assessing to quote what extent criminal immunity applies, the court should be guided by 4 considerations. So you should just dismiss it outright. But if not, let's talk about this outer perimeter. First, this is consistent with the Nixon versus Fitzgerald case. They say the scope of immunity should extend to the quote outer perimeter of a president's official acts. That's from Nixon. And its protection should be absolute. It's not qualified. And again, in legal terms, not absolute in MSNBC terms. Establishing criminal immunity as coextensive with civil immunity follows the compelling logic of Fitzgerald, right? In the Nixon-Fitzgerald case, they said, yes, clearly a president needs immunity from civil claims. So if you found it was necessary then, how can you not find it's necessary now? It reflects this court's preference for bright line rules rather than case-by-case adjudication. And it also protects Article III courts from being drawn into a vortex of political disputes every single time an immunity question is raised. And second, if this court determines that immunity exists, but if it does require a fact-based application, like if you want to dig in and talk about Trump, because that's exactly what they're talking about in a lot of these lower courts, it's, well, the rules are this, the rules are that, but Trump, we can't help it because he's such a danger. The court should follow its standard practice. Don't hear that, the facts here. Send this back to the lower courts, make them conduct the fact-finding, and then we'll come back up here. And third, if this court does adopt a form of qualified immunity, which it should not do, the court should emphasize 2 features of that doctrine. First, the breadth of the qualified immunity protection corresponds to the official duties, which in any case are extraordinarily and almost completely broad. So remember, we have the outer perimeter concept. What is the official duties and what is not? They argue for a broad protection. For example, distinguishing between protecting the election against being rigged versus campaigning to have a second term and, have office again. Like one of those is personal personal, the other is presidential. Second, qualified immunity also requires a high degree of specificity, defining the unlawful conduct with obvious clarity, and that should also guide this if you remand this. And fourth, you should also reject the circuit court's alternative approach. And Chutkan came up with this weird thing where she said, Donald Trump, he wanted to remain in power unlawfully, right? So if you have a bad motive, that will breach your immunity. That was Chutkan's deranged argument. Now, this approach contradicts Marbury, holding that a president's official acts can never be examinable by the courts. Not, okay, now we can examine it because you're trying to stay in power. It cannot be squared with this court's holding, reaffirmed in a long line of cases that official immunity does not turn on the alleged purpose or motive. So it doesn't really matter what Trump was thinking in his mind. He gets to claim immunity. And indeed, because virtually all first-term presidents and their official actions carry some at least partial motivation to be reelected, right? Every president in his first term is taking every official act with an eye towards reelection. So how do you separate the meat from the meat sauce? Further, such a case-by-case approach would continually shove this court right into the middle of these complexities, and this approach risks creating the appearance of a gerrymandered ruling tailored to deprive Trump of immunity while leaving all of the other presidents untouched. Now, here's the argument. We have Trump's defense arguing to the Supreme Court that a former president enjoys absolute immunity from criminal prosecution. They say, in view of the special nature of the president's office and functions, absolute immunity is necessary for anything within the outer perimeter of his official responsibility. That's a U.S. Supreme Court case. The conclusion rests on the Constitution's text and the structure. They all point the same direction. A former president has absolute immunity from criminal prosecution. How do we know? Article 2, Section 1 of the Constitution tells us, the executive power shall be vested in a president of the United States, not in Congress, not in the courts, in the president. Under this clause in the separation of powers that it commands, Article 3 courts lack authority to judge the president. It doesn't say the executive power shall be vested in a president unless the president is named Donald Trump, or unless the president tries to remain in office, then the judiciary can take over. It's not in there. This clause has been consistently understood as this way, all the way back from 1803 in Marbury, all the way up to Fitzgerald, and now to the present day. In Marbury versus Madison, and this is, just a great case, the Attorney General Charles Lee, he declared his opinion that the president is not amenable to any court of judicature for the exercise of his high functions, but he's responsible only in the mode pointed out in the Constitution, and the Chief Justice agreed. He said, by the Constitution of the U.S., the president is invested with certain important political powers, in the exercise of which he is to use his own discretion, and he's accountable only to his country in his political character and to his own conscience. And whatever opinion may be entertained of the manner in which the executive discretion may be used, still there exists and can exist no power to control that discretion. Why? It is entrusted to the executive. The decision of the executive is conclusive. You can't second guess them. In cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear that the president's acts are only politically examinable. Accordingly, the official acts can never be examinable by the courts. And if you want to prosecute, you got to impeach, which we'll get to. An unbroken line of authority also confirms this. Again, the court declined to exercise jurisdiction over President Madison's official acts of the War of 1812. They rejected the notion that the president's official acts could be passed upon a jury, right? You can say, well, let's see if that was really what the president should have done there. We don't govern by jury, having them judge whether the president's orders are legal or not. The remedy for this is found in the Constitution. If you do want to question the president, impeach them. That's what the Constitution says. Now, Justice Story also cites Marbury, and Justice Story, as we've talked about, is one of the most quoted judges in America. He wrote in 1833, he said that in the exercise of his political power, the president is to use his own discretion, accountable only to his country, and his decision is conclusive. No one can question it. The courts can't do it. Congress can't do it. The court reaffirmed the doctrine in another case, and in Mississippi, they said that the court lacked jurisdiction to enter an injunction against President Johnson to prevent him from enforcing the Reconstruction Acts. They said the president is the executive department. It cannot be restrained in its action by the judicial department. An attempt on the part of the judicial department of the government to enforce the performance of those duties by the president might be justly characterized in the language of Justice Marshall as an absurd and an excessive extravagance. Oh, Trump did a bad thing as the president, therefore he goes to jail because some judges and some jury somewhere said so? No, it's not how this works. This immunity is necessary trying to avoid a collusion between the branches. This court has no jurisdiction of a bill to stop the president in the performance of official duties. Now, remember, there's a distinction here between the president and the president's officers. Again, it's a big difference. Congress can do stuff with the presidential officers, right? Create offices and do other things, but it's not applicable to the president himself. In 1948, this court also held that official acts that embody the presidential discretion as to political matters are beyond the competence of the courts to adjudicate. That's for the people to decide. If the people think that Trump is an insurrectionist and that he abused his office to stay in power or whatever, we'll vote him out. We'll have our say at the ballot box. That's the jury. It's the political process. It's not a DC jury in Washington, DC or New York. It's for us to decide. Now, such matters involve the exercise of unreviewable presidential discretion. So no court has the authority to direct the president to take an official act, right? You can't have a court say, Mr. President, you have to do this or you have to do this. What? So that judge is the president then. Article 3 courts may not require the president to exercise their discretion in a judicially prescribed fashion. No court has ever issued an injunction against the president himself or held him in contempt of court. It's incompatible with the position constitutionally that the president be personally compelled to defend his executive actions. Now, thus, Supreme Court, an apparently unbroken historical tradition implicit that dictates that a president may not be ordered to perform executive acts has been here for a long time. A lot of case law being cited. In Nixon, the court held that the president enjoys absolute immunity from civil liability, and further held that immunity is functionally mandated incident of the president's unique office, right? So we're going to see Fitzgerald, is going to be the crux of this case. Fitzgerald lies squarely in the tradition of Marbury. The president's official acts can never be examined, and the courts, therefore, cannot impose civil liability on him. The court would impose the liability on the president for his official acts. You can't do that. Now, Article 3 courts, what follows from that is they also cannot sit in criminal judgment either, because the courts cannot examine the official acts. And because they can't do that, they can't entertain charges. They can't impose judgment. They can't imprison the president. They cannot conduct a jury trial. When the president exercises an authority, including a former president, a jury cannot pass upon that. They say the specter of criminal prosecution of a former president without first being impeached by a 2/3 majority creates a maximal intrusion on the independence of the executive, far greater than any threat posed by another relief, like injunction or declaratory relief. The president is personally vulnerable, and criminal prosecution makes things much more vulnerable. And so we cannot have this prosecution. In fact, there has been no history or tradition of prosecuting presidents for this conduct at all. And now they transition in subsection B. They talk about the Impeachment Judgment Clause, a very important part of the Constitution. They say the text of the Impeachment Judgment Clause confirms the original meaning of the vesting clause, that current and former presidents are immune from criminal prosecution for official acts. The Impeachment Judgment Clause provides that after impeachment and a Senate trial, the party convicted, ED, shall nevertheless be liable and subject to indictment, trial, and judgment. So after you're impeached and convicted, yeah, you can be prosecuted. Fair game. It says party convicted in quotes, which means you got to be convicted. So the Constitution actually gives us the rules. It provides for impeachment and conviction by the political branches. It vitally requires a 2/3 majority of the Senate, and it also requires a nationwide political consensus. Everybody says, okay, this dude did something bad. He's got to go. It's a structural check against presidential malfeasance. Thomas wrote about this in a dissent. He said, to a limited extent, the Constitution contains a partial intermixture of those departments for special purposes. One of the special purposes is the system of checks and balances, and impeachment is one of those checks. And he quoted Hamilton in Federalist 66. So the Impeachment Judgment Clause is pretty clear. It presupposes that an unimpeached and an unconvicted president is nonetheless immune from prosecution. By specifying the consequences of only one of the two possible outcomes of impeachment, it says that the consequences do not apply to the other outcome, right? So if you are convicted, then you are subject to the other penalties. But if not, then it doesn't apply. Read the clause. Its plain implication is that criminal prosecution, like removal from the presidency, is a consequence that comes only after the Senate's judgment. This is exactly how Alexander Hamilton explained it. Back in the Federalist Papers, here's what Hamilton said. He described criminal prosecution of a president as a consequence of impeachment conviction. And he wrote 3 times that prosecution of the president can only come after and subsequent to the Senate conviction. He said, quote, the punishment which may be the consequence of conviction upon impeachment is not to terminate the chastisement of the offender after having been sentenced to perpetual ostracism from the esteem and confidence and honors and emoluments of his country, he will still be liable to prosecution and punishment in the ordinary course of the law. Now, the President, he also said, of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes and misdemeanors, he would be removed from office and would afterwards, Hamilton again, be liable to prosecution and punishment in the ordinary course of the law. He also said for the third time, this is point number 3 from Hamilton, the President is at all times liable to impeachment, trial, and dismission from office, incapacity to serve in any other, and a forfeiture of his life and estate by subsequent prosecution in the common course of the law, right? So impeachment comes first, prosecution comes second. Now, the decisive weight of evidence from the Founding Fathers Supreme Court also confirms what Hamilton said. As noted above, Chief Justice Marshall, Attorney General Lee, Justice Story, they all shared Hamilton's view. Impeachment, not prosecution in Article 3 courts, that was the constitutional check against presidential malfeasance. That's why they wrote it in there. James Wilson likewise asserted that the president is amenable to the laws in his private character as a citizen and in his public character by impeachment. Wrote that 1863. And so likewise, this court, Supreme Court, has consistently held that the impeachment and the removal process, not litigation in Article 3 courts, provides the constitutionally sanctioned check against presidential misconduct, saying this court has reiterated this point for over 2 centuries. A lot of case law. Now, the government itself, through the DOJ, they acknowledge this. They say that where the president is concerned, only the House of Representatives has the authority to bring charges of criminal misconduct, through the constitutionally sanctioned process of an impeachment. So how come the DOJ says this in their own document and then charged him? Oh, because he left office? Is that why? Where the president is concerned, only the House of Representatives. No, apparently Jack Smith didn't read this. He didn't get this memo. So this was written in 2000, a sitting president's amenability to indictment and criminal prosecution. They said the constitutionally prescribed process of impeachment and removal lies in the hands of the duly elected and the politically accountable officials. Jack Smith is not politically accountable. Neither is Merrick Garland. So we want it to go to the Senate, not to jurors and Judge Chutkan. The House and the Senate are the appropriate institutional actors, right? If you really want democracy, as the left keeps hyperventilating about, you let the country make their decision. Let us go to the polls and participate. You don't take the decision away from us, trying to throw him off the ballot in Colorado and everywhere else, and then also try to imprison him. Congress is structurally designed to consider and reflect the interests of the entire nation, and individual members of Congress must ultimately account for their decisions to their constituencies. And by contrast, the most important decisions in this process of criminal prosecution, if we go your way, would lie in the hands of unaccountable grand and petite jurors, like Elizabeth Coors from Georgia, deliberating in secret, perhaps influenced by Big Fannie Willis and other concerns that most of us don't care about, guided by a prosecutor who's only indirectly accountable to the public. Doesn't work. Now, the DC Circuit Court also emphasized the historical practice of prosecuting subordinate officers before they're impeached and convicted. But as the DC Circuit Court also noted, the Supreme Court has repeatedly emphasized that the president is sui generis, occupies a unique position. It's literally a unique status. Thus, this court has long recognized the scope of presidential immunity is vastly different from other offices. And the DOJ also further admits that the impeachment judgment clause does not contemplate that the practice of pre-impeachment prosecution of subordinate officers would also extend to the president. They go back, they cite this analysis, 1973, Robert Bork. They also talk about this brief. In 1973, Bork wrote that the convention debates distinguished the president from subordinate officials. Certainly nothing in the debates would suggest that the immunity contemplated for the president would extend to any lesser officer. Clearly, they're not, it's a whole different ballgame. But this interpretation does not apply to the president. There are substantial reasons embedded not only in the constitutional framework, but in the exigencies of the government for distinguishing the president from all of the other offices, including the vice president, right? Like, you need a root starting point. You need someone who has the ultimate power. Like, the buck stops with someone. We've decided it's the president, not Deborah Stidel Wall from NARA, not Liz Cheney on her illegally constituted committee, not Jack Smith illegally appointed and stealing money from illegal appropriations. According to the DOJ, founders understood, and the impeachment judgment clause entails, that subordinate officials could be subject to prosecution without first being impeached in the House, but the president could not. Therefore, the impeachment judgment clause directly addresses the DC court's emphasis on the fundamental interest in the enforcement of criminal laws, right? That's what they always say. Fundamental interest on the enforcement of criminal laws. Well, just impeach him. You tried, you missed, you failed. So you don't get 2 two bites at the apple. Sorry. The founders weighed that the fundamental interest against the countervailing interest, far more pressing in their eyes, in avoiding the cycles of recrimination that have been the great engines by which violent factions have wreaked havoc on each other and destroyed a free government. Political prosecutions of your opponents wrecks the country. Founders knew that. They said, look, you can only do that if you pass this political threshold. Like, both sides have to be disgusted by the person, impeached and removed. Okay, everybody says, all right, clearly criminal. Get rid of him and prosecute him. That did not happen here. Now, the founders carefully adopted a balanced approach that permits the criminal prosecution of a former president for his official acts, but only if that president is first impeached and convicted by the Senate. Yes, we know it's a formidable structural check, but that's America. We elected that president. So in order to remove him and prosecute that person, it's got to be a pretty high bar. So the DC Circuit evidently preferred a different calculus, but it had no authority to rebalance what the founders had already weighed. So they can't just make it up. They say, Supreme Court, by the way, the presuppositions of our political history also support our argument. They say this original understanding, it also draws further support, from 234 years of unbroken traditions of not prosecuting former presidents. A lot of other people had ample motive and opportunity to do so, but they didn't. American history abounds with examples of presidents who were allegedly accused of committing crimes, but no one was ever prosecuted. Not one. Not from 1789 until 2023. And a bunch of the smooth brains on the other side will say, well, no one has done anything as bad as Trump. No one's misconduct is as egregious as his. Okay. Why? Because he stood up there and gave a speech on January 6th and said our election was rigged when it was? American history contains no shortage of examples of presidents committing criminal official acts, they say. At least in the eyes of their opponents, every opponent says their political opponent's a criminal. Oh, I can't believe he did that. This is unconstitutional. It's totally ridiculous. John Quincy Adams was accused of a corrupt bargain. He appointed Henry Clay as the Secretary of State after Henry Clay gave him the election. No one indicted anybody there. Andrew Jackson literally ignored the court's rulings, forced the resettlement of many people, resulted in the infamous Trail of Tears. Thousands of Native Americans died. Roosevelt, no one indicted Jackson. Roosevelt imprisoned over 100,000 Japanese American citizens during World War II. Our government, communists, Roosevelt did that. No one indicted him. Clinton repeatedly launched military strikes in the Middle East on the eve of critical developments covering up his cigar situation with Monica. No one indicted him, with the likely goal of deflecting attention. Clinton pardoned fugitive financier Mark Rich, resulting in widespread accusations of criminal corruption, including an illegal quid pro quo. No one indicted him. George Bush was accused of knowingly providing false information to Congress, lying about Saddam and his weapons of mass destruction, launched an Iraq war, 4,400 Americans dead, may they rest in peace, with almost 32,000 wounded, and prayers to them. President Obama did the same thing, targeted and killed U.S. citizens abroad by drone strike without any due process, murdering Americans. They're abroad and who knows what they were doing, but it's still American citizen, and he doesn't have the lawful authority to do that. Maybe someone should indict him. Special counsel admitted that a drone strike where civilians were killed might be the kind of place where the court would properly recognize immunity. They would say, oh, well, if Obama killed some American citizens, that's okay, because he's immune and he's doing it for the safety of America. But Trump encouraging his DOJ, Mike Pence, Secretary of State officials, and posting tweets, that's worthy of a criminal prosecution, but not drone strikes that kill people, or the imprisoning of 100,000 Americans, or George Bush lying to us to get us into a war. Trump was worse than all of those people. Are you serious? That's their argument. Just to be clear, they say, yes, Rob, I'm serious. Yes, I am. Trump is worse than them, all of them. Biden's mismanagement of the southern border, dealings with Iran, paying them money that's ending up in fronts that are causing problems throughout the world, and funding literally pro-Hamas groups. How come Joe Biden's not being indicted? In all of these instances, the president's political opponents routinely accuse him and currently accuse Biden of criminal behavior in his official acts. In such case, each opponent later came to power with ample incentive to charge him. But no former president was ever prosecuted for official acts until 2023. Now, such a lack of historical precedent is generally a pretty telling indication of a severe constitutional problem with that new asserted power. A lot of smart people have come before Jack Smith. A lot of people have thought, can we take this person out? But no one's ever actually done it because our country is being commandeered. Fitzgerald also likewise emphasized that powerful support for immunity also derives from the actual history of private lawsuits against the president. Fewer than a handful of actions were ever filed against the president. Almost none have ever appeared to move forward on the merits. And if you look at this history, it confirms criminal immunity exists. And the common law supports this claim as well. In fact, when it comes to protecting the independence of coordinate branches, criminal prosecution was the chief fear in all these doctrines. We weren't even worried about civil liability. We were worried about criminal liability. Criminal prosecution presents a mortal threat to the presidency's independence. We know that civil immunity alone was enough to impede the effective functioning of the government, and the prominence of the president's office cannot be ignored. He's an easily identifiable target. There are 2,300 DAs across this country who would love to prosecute him. This concern is compelling, and we do not want this to cripple our constitutional system. They say the threat of future prosecution will also cripple the current presidential decision-making. So you might be in office, you might want to make a tough decision. You've got the, Jack Bauer 24 countdown, beep, beep, beep. You don't know what you have to do. You make a decision, but you say, I'm just not going to make a decision because Fani Willis might indict me when I get done. And she might. Among the most persuasive reasons supporting official immunity is the prospect that damages liability may render the official unduly cautious because they're afraid of what Fani Willis is going to do. In Vance, the court also emphasized that the Fitzgerald dominant concern was the distortion, the perversion of the executive branch's decision-making process. Immunity exists to protect officials' ability to make decisions based on their own unbiased beliefs. And the threat of future criminal prosecution would distort this, and it would impact the most sensitive and far-reaching decisions of the presidency. And also, criminal prosecution carries a far greater stigma and even more severe penalties. The government itself, through the DOJ, notes this. In short, a president who's concerned about an ongoing criminal investigation is not going to do a good job as president. And Judge Chutkan and the DC Circuit also wrongfully reasoned that the instant prosecution of Trump is likely to be a historically isolated instance, right? This is the Trump exception. We're never going to do this again. We only have to do this for Trump because he's such a bad guy, which in itself points to an unconstitutional and gerrymandered selective prosecution approach. Given that Trump is facing not one, but 4 simultaneous prosecutions as well as civil cases that closely resemble criminal prosecutions, this prediction overlooks current realities. Moreover, it contradicts the reasoning in Fitzgerald. And of course it does, right? Like, they just say Trump's conduct was so bad. Okay, which conduct was so bad? Like, they say all of it, right? It was so bad, it was so egregious, no other president has done anything like it. No other president has questioned a prior election. No other president has taken documents with them. No other president has entered into a contract to, pay off some story to go away, right? Every one of them has. And the RICO case is just an extension of the fake J6 prosecution. So they're all of them can't possibly be exceptions. Like, I thought J6 was just really bad since the Civil War. And so we made an exception on this, but also the classified documents we made an exception on. And also Alvin Bragg, and also Fani Willis, and also Tish James taking over $500 million in his property. It's like, weird, a lot of exceptions for this one dude. Or is it that you guys have now given the green light on lawfare because you cannot stop him any other way? This is it. It's your last gasp. It contradicts the reasoning of Fitzgerald, which noted the prior scarcity of civil cases. But they noted that the scarcity would vanish once the floodgates were open. And look, we're living it. The recent history of presidential impeachment confirms Fitzgerald's reasoning. And this is a great point, right? Our country is going through a major shift right now. And if you have any doubt about it, just look at the pattern and the trend. In 209 years, from 1789 to 1998, there was only one impeachment of a president, Andrew Johnson. That's it, until 1998. Now, in the most recent 26 years, there have been 3, with a 4th under active consideration by the House of Representatives. Trump got 2 of those. In a few decades, presidential impeachments has transformed into a fixture of interbranch conflict, right? So our politics have entered a new realm. Now it's impeachment and litigation. Criminal prosecution of former presidents will follow this path much more swiftly. Impeachment faces formidable structural hurdles by design to slow this whole thing down, including support from the majority of the House and a supermajority of the Senate. Criminal prosecution, by contrast, requires only a single Fani and a compliant grand jury, Elizabeth Kors, who's, be your own judge of her capacity. Indeed, if immunity is not recognized, every future president will be forced to grapple with the prospect of being criminally prosecuted after leaving office every time he or she makes a controversial decision. That would be the end of the presidency as we know it, and it would irreparably damage our republic. And I agree. It would actually, I think, be a major victory for the deep state. It would essentially subsume the presidency into the blob, into this gigantic, deep state, cavernous bureaucracy, because now the president would be subject to all of the criminal prosecutions, regardless of their legitimacy. Now, here is where they smash the other arguments. They tell us, the counter arguments are garbage. First, let's talk about these official acts. They say that Marbury and its progeny, its, children cases, are all meritless. They say that's ridiculous. First of all, Jack Smith's an idiot. He admits that a president's official acts are not subject to injunctive power of Article 3 courts. So Jack even admits that courts cannot force a president to do something. So he's like, okay, that sounds good, right? That's like in alignment with our principles. You can't force them to do anything, otherwise you're the president. But simultaneously, he argues that under Marbury, this immunity vanishes once that president leaves office. Now, this argument also contradicts Marbury, which held that a president's official acts can never be examinable by the courts. They said the questions, which are by the Constitution and laws submitted to the executive, Marbury says never. The argument also contradicts Justice Story, who wrote he's accountable only to his country and his own conscience, and that his discretion is conclusive. It contradicts Martin, saying that none of this could be passed upon by a jury, and it's at loggerheads with Fitzgerald, which held that former President Nixon was protected by absolute civil immunity, Jack. So how come you're so dumb? The requirement for criminal immunity for presidents is even more urgent than that for civil immunity, Jack. So don't say, right now we're talking about the distinction between in office and out of office. Jack says once you're out of office, it evaporates. That kind of undermines the entire point of having immunity. So second, the DC Circuit attempted to distinguish Marbury by holding that a president has a ministerial duty to comply with generally applicable laws. Now, Jack Smith does not even defend this distinction because it's idiotic. Chutkin threw that in there. Man, she's not good. Which contradicts the DOJ's previous litigation position. And the distinction is meritless. She just made it up out of her derriere. The duty to comply with generally applicable criminal laws cannot plausibly be described as ministerial. Rather, it is quintessentially discretionary. A ministerial duty is a precise course accurately marked out by law, which is to be strictly pursued. It is a simple, definite duty, something that where nothing is left to discretion. Okay, criminal laws prohibit broad and many times ill-identified forms of conduct while leaving their subjects with a wide range of discretion on how to behave without violating the law. Thus, the obligation to comply with criminal laws necessarily involves boundless use of discretion. In fact, no court has held that the president has any ministerial duties, and the president's unique role as chief executive is based on discretion mandated by the separation of powers. So Chutkin, again, just made it up, as we said. Now, third, both Jack Smith and the DC Circuit, they both point out that Article 3 courts do, in some circumstances, review the legality of president's official acts carried out by the executive branch. But as the DC Circuit admits, all of those were over subordinate positions. Again, I'd have no problem with that. The writ in Marbury was brought against the Secretary of State. That was against another commander in that case. And so none of these cases cast doubts on any of the other holdings. Article 3 courts cannot sit in judgment of a president. So you can bring up cases where it's not the president, but okay, that's fine. It's not persuasive because it's not the president. Here, as elsewhere, the president and his unique status under the Constitution distinguishes him from other executive officials, a distinction reinforced over, 2 centuries. The court has long recognized the scope of presidential immunity is very different than that of a cabinet or inferior officer. We have saying a president has different privileges and rights. He has to decide other things that subordinate officers don't. And so there's a difference between the president and the other positions. Now, they also talk about the presumption of regularity. So Jack Smith, again, Trump is responding to Jack Smith's arguments at the Supreme Court. He says the special counsel Jack relies heavily on the, quote, presumption of regularity in the government's actions. In other words, saying you can trust the government is doing a good job and they're honest and they say they're doing what they're doing and they're not doing anything below board. That presumption of regularity has no application here. It's fully contradicted by the precedent of 234 years of our nation's history. The founders recognized that the prosecution of a president is inherently political, and it must be assigned to the political branches under the Impeachment Judgment Clause. And that wisdom endured all throughout our country until last year. It's a sick thing, isn't it? A political attack should be brought in the political branches, not by Jack Smith. Now, the founders were keenly aware that politically motivated prosecutions pose a grave threat to Republican governments. James Madison warned. He said, newfangled and artificial treasons, right? You committed an insurrection. Artificial treasons have been the great engines by which violent factions, the natural offspring of free government have usually wreaked their alternate malignity on each other. So a free government creates powerful factions. Those powerful factions will then blame one another for committing treason, and they'll make it fake treason when we're living through it literally right now with this insurrection thing. Federalist number 43. Madison can see it. Hamilton also likewise wrote that offenses committed through the president's official acts are of a nature which may be with peculiar propriety be denominated political, and thus prosecution of them for this reason will seldom fail to agitate the passions of the whole and divide it into more or less parties. Says in many cases, a prosecution is going to connect itself with the pre-existing factions, and it's going to increase the animosities, the influence, and the interest. And there will always be greater danger that the decision will be regulated by the comparative strengths of the parties than by any real demonstrations of innocence or guilt. Okay, so our founders are a lot smarter than Joe Biden and Merrick Garland and Jack Smith or Fannie Willis. If you allow these things to bubble up, no one even cares about innocence or guilt anymore, right? It just turns into a political battle. We're living it. Thus, Hamilton reasoned, he said, the trial of those offenses which proceed from the misconduct of the public officials should not proceed in Article 3 courts. The Supreme Court would have been an improper substitute for the Senate as a court of impeachments. Among other reasons, Article 3 courts are ill-equipped to handle political battles. The DOJ also recognizes this. The prosecution of a president is necessary political in a way that criminal proceedings against other civil officers would not be. It's unavoidably political. And the DOJ admits that it would be incongruous for a jury of 12 to undertake the unavoidably political task of rendering a judgment against the president. Well, they're trying to do that in 4 different states now. Here's another footnote. President Ford's pardon of President Nixon reflects this judgment. Ford stated that Nixon could not hope to obtain a fair trial by jury in any jurisdiction. The passions would be aroused, right? Never going to happen. Now they're using that as a feature, not a bug. Now, immunity does not actually place the president above the law, no matter how hard they hyperventilate otherwise. Jack Smith, Chutkin, and everyone else, they cry that immunity would place the president, quote, above the law, and no one's above the law. As Fitzgerald said in that opinion, this contention is rhetorically chilling, but it's wholly unjustified. The remedy of impeachment demonstrates the president is accountable for his misdeeds. It's simply error to characterize that someone's above the law because a particular remedy is not available against him. This is even more true here. The impeachment judgment clause explicitly authorizes, literally, it permits criminal prosecution of a president if he is impeached and convicted. Now, Fitzgerald says a rule of absolute immunity, the legal term, not the deranged term, will not leave the nation without protection. There is a big remedy. Formal, informal checks, constant scrutiny by the press, vigilant oversight by Congress, credible threats of impeachment, and alternative remedies as well. The founders envisioned that impeachment and other checks and balances are plenty, and they are. Now, the special counsel objects to these authorities. They say, wait, if impeachment, conviction, and conviction are prerequisites, some presidents who engage in wrongdoing, they might escape criminal punishment, such as those who conceal their official crimes until after they leave office, and those for whom the political consensus needed for a Senate conviction does not materialize. But nevertheless, as to grave offenses, the DOJ itself notes that the president who commits grievous wrongdoing, creating the political census for their punishment, will face speedy impeachment and conviction in the Senate. They say, but even if some level of presidential malfeasance, not present in this case at all, were to escape punishment, that risk is inherent in the Constitution's design. The founders viewed protecting the independence of the presidency as well worth the risk that some presidents might evade punishment in marginal cases. They were willing to burn the presidency itself to the ground to get at every single alleged malefactor. Indeed, every structural check in the Constitution carries a similar risk of under-enforcement. While the separation of powers may prevent us from righting every single wrong, it does so in order to ensure that we do not lose liberty. So we understand, right? Separation of powers is not 100% perfect, but it's necessary to protect our liberty. Now, generally applicable laws, as they continue, say the court should order the dismissal of this indictment, but if they don't, then we do need to talk about what level of criminal immunity applies here. They say Congress must speak clearly to apply a statute, and it would require an express statement from Congress before that statute is valid. And the courts can't just read in some new statute. So the court applies a clear statement rules, and how it applies to Trump, they say, Trump is charged with these various statutes, 1512C2, K, and so on. Now, none of these statutes mentions the president. Each statute must be stretched so far beyond its natural meaning to apply to a president's official acts that the statutes become unrecognizable. For example, conspire to defraud the United States. What are you talking about? He was trying to make sure our election was not rigged, conspiring to violate, conspiring to injure. Now, for example, they say, quote, all agree that the enactment of 1512 was prompted by the Enron scandal. The statute contains no clear indication of Congress's intent to criminalize a president for talking to, the vice president, talking to members of Congress, talking to state officials. And all these other statutes contain no clear statement that Congress intended to criminalize any official action of the president. These are generally applicable statutes. And he was talking to his DOJ, to his cabinet level officials. None of the statutes in Jack Smith's indictment clearly authorizes the criminalization of the official acts or the strained interpretations that Jack Smith tries to advance here. And so accordingly, this should be dismissed because Trump is not subject to review. Now, they tell us if Trump is not absolutely immune, then we need to talk about what other levels of immunity exist. You asked us, what level, to what extent does this apply? Now, Jack Smith himself admits that criminal immunity likely applies to at least some official acts of the president because he said we could kill citizens. For example, Jack Smith even admitted that Obama can drone strike U.S. civilians, and maybe there is some kind of immunity there. Then he admitted in another briefing that the indictment charges Trump with the use of official power. And these admissions concede some level of a criminal immunity must exist, so you should apply it here. So then the next questions are about what is the size of the scope? How should we include it? We say that there is absolute immunity, and Fitzgerald says that it should be immune from stuff that is within the outer perimeter of your official duties. Several considerations favor this. It matches civil immunity. At common law, this was also protected. There are reasons for recognizing criminal immunity to ensure the independence of the various branches. It also follows from Marbury and its progeny. And immunity also might, here's another possible interpretation of this. It's the functional approach. So how do we define the scope of an official's absolute privilege? So, is it this level of action, or does it extend all the way out here, or is it all the way out here? They say the court must recognize that the sphere of protected action must be related to the immunity's justifying purposes. And the court has also refused to use functional lines. And so we're asking, what is the president's duties, right? What are his discretionary responsibilities? And in many cases, they say it would be very difficult to determine what is what. If you adopt a bright line approach, it avoids a case-by-case adjudication of these immunity claims. In Clinton, the court stated that if the framers of the Constitution had thought it necessary to protect the president from litigation, we think it far more likely that they would have adopted a categorical rule than a rule that required the president to litigate a question whether the case belonged to a subcategory. Okay, so if Trump doesn't win on absolute immunity, they're talking about other potential theses, but either way, the court should remand this case if necessary. The court should dismiss the indictment, but if the court concludes that criminal immunity exists generally, but if you require further fact-finding, send this back down. No court has addressed the application of immunity to the facts of this case, and so if the indictment is not dismissed, send it back down to Chutkan's courtroom. They tell us more about Fitzgerald, and here is where they're talking about not gerrymandering this case. Something we've seen a lot here is Chutkan and the circuit courts, they always say, but Trump. Trump is so bad. We know this case is kind of abnormal, but Trump is so bad, so we're not even going to sign our per curiam opinion, and we're just going to get it out. Now, the court should not create an unconstitutional Trump exception. They say, though it rejected criminal immunity as a categorical matter, the D.C. Circuit advanced a meritless holding to deny immunity to, quote, Trump in particular. Chutkan and the D.C. Circuit said that a president is not immune from prosecution if part of the motivation was that he wanted to stay beyond his term. The court should reject that gerrymandered approach for several reasons. One, obviously, it disagrees with Marbury. Marbury said you can never examine, and the president has discretion. And second, that approach contradicts this court holding that immunity decisions do not turn on their purpose or motive. Improper motive is almost always alleged, so if you decided to say that, everybody would say it every time, no one would have immunity at all. Now, the D.C. Circuit rests on their allegation of an improper motive. They said he wasn't immune because he had an improper motive. But the D.C. Circuit, when they ordered this, they contradicted Fitzgerald. The DOJ has written that this court has emphatically rejected an argument that you lose immunity just based on your motivation. And third, this supposedly narrow exception would also rapidly swallow the rule. They say that if you allow this to continue, there will be a vortex of political disputes all over the place. We'll ask a question about whether the president's conduct was really motivated by an improper purpose. We're going to have to get into the president's mind on everything. Was Bill Clinton's military strikes in the Middle East, were those really to go, quell a conflict, or were those really to just wag the dog and get everybody forgetting about Monica Lewinsky? Was Bush's weapons of mass destruction election actually motivated by looking for terror, or did he just want to get reelected? Is Biden destroying our southern border, undermining national security for unlawful electoral purposes? Maybe. If we are allowed to investigate all of these political motivations in a president's mind, this is going to get problematic. So in sum, the lower court's holdings about a president's motivations are not tenable. As the DOJ has themselves written, the constitutional concern is not merely that any particular indictment would impinge his duties, but it's a bigger concern. And so the consequences are not confined here to President Trump alone. No, instead, they will affect the presidency and the rest of our nation's history. This court should not adopt a rule that creates the appearance of a President Trump-only gerrymander. And, gerrymandering, it's like when they draw congressional districts like this, and they draw them like all the way out like this. And then in this area, it's like all of the Democrat voters, like it's all Democrats, like in this area. Like, how about you just gerrymander, how about just draw your districts like this, right? They say, no, we draw it like that. And because we rig a district. That would be the antithesis of the rule of law. Saying this court should reverse Chutkan and order the dismissal of the indictment. If this court finds fact-finding necessary, it should remand the district court to apply the doctrine in the first instance. Big whopper of a filing, my friends. 67 pages done by Lauro and Blanche and Otis, submitted in front of the Supreme Court of the United States. And here are all the other provisions that they were citing. And so, woof, okay, my friends. So this is a big one. And I think it is absolutely right. I think that they have this law right. And Chutkan's analysis and all of the lefty analysis that says Trump doesn't have any immunity, I think goes in the face of history and our law here. Now, the one concern that I might have is that we might see that the scope of the immunity or the outer perimeter test, right, they might put January 6th outside up here. They might say, oh, January 6th was out here. The president does have immunity. It's pretty strong immunity, but they just throw January 6th outside of that immunity. They come out with a presidential immunity test and they conveniently put Trump outside so that the trial can move forward. But a lot of these arguments are arguments we've seen fleshed out. I think that they get a little bit more dialed in every single time that we go through them, but it's a big day. It's a big brief. And I know this show was a lot of reading and a lot to unpack here, but I think it's important that we anchor this in because we're going to see Jack Smith issue his reply brief or his response brief and then Trump's reply. And then we've got oral arguments coming up April 25th next month. So we're going to be here covering these oral arguments. I agree with this brief that if the Supreme Court does not find that there is presidential immunity, I'll think that in terms of practical application of how the presidency will work, it will now be gobbled up by the lawyers, essentially, by the prosecutors. And there are plenty of other ways to prosecute a president. All you got to do is impeach them and convict them. Very simple. But they couldn't do that with Trump. And now they're panicked. They're pulling out all the stops, breaking glass in case of emergency to try to convict him. And we'll see what the Supreme Court does in response. And so that, my friends, is it for us here on The Day. I will encourage you to subscribe to our channel. Thank you for liking this video. We're going to be covering all of the Trump litigation as it continues to unfold. And we'll look forward to seeing you back here on the next one.